Good evening. I'm attorney Catherine Henry with the Restore Freedom Initiative and Catherine Henry PC. Tonight I wanted to give you an update on the legislature's lawsuit against the governor. As many of you already know, it didn't exactly go the way the legislature wanted it to. In fact, for any of you who are watching now, who also watched me speak about this in the last couple of videos, you know that it went exactly the way that I said it would, which is the two female judges on that panel voted in favor of the governor's nonsense, and the third judge, the male judge that was on that panel, would have had the court go in a different direction. Essentially, what he said is, in a lot of respects, things that I submitted in my briefs on this case as well. So, very briefly, this is, the case I'm talking about is in fact the legislature's lawsuit against the governor. This was at the stage where the legislature, they first filed the lawsuit that was brought in front of the Court of Claims. It's essentially the trial level court where you sue the government. So they didn't have a full trial. They had oral argument. They just had motions. And then the Court of Claims judge made a decision based on those motions, and both the governor and the legislature appealed those decisions to the Court of Appeals. The legislature and the governor both then tried to utilize provisions of the Michigan court rules that would have allowed them to jump over the stage of having the Court of Appeals hear the case, and would allow it to get in front of the Michigan Supreme Court right away. However, and that was the first brief I wrote essentially on behalf of the people of Michigan and our Michigan and U.S. constitutions. I was the only attorney to file and have a brief accepted as an amicus in that stage of the case by the Supreme Court of Michigan. And so June 4th, sadly enough, or ironically enough as it is, the very same motion that accepted my brief also was the very same order that accepted my brief was also the same order in which the court said that they were going to send the case essentially back down to the Court of Appeals and have it fully fleshed out at that level first. That wasn't a total loss, though, because the three justices who wrote a dissent at that time really had quite amazing things to say, things that have helped to shape some of the arguments that I have, in fact, been making since then, including in the brief that I wrote then at the Court of Appeals level on this case, and the brief that I submitted a couple weeks ago to the Supreme Court of Michigan itself in a totally different case. So, at any event, the case was, in fact, sent back down to the Court of Appeals. That at that stage, there were, there are several amicus briefs that had been submitted, and of course, the legislature submitted a brief, and the governor submitted a brief, and a group of attorneys who were essentially trying to intervene to become officially part of the lawsuit, they also submitted a brief. There were actually multiple motions and briefs at the Court of Appeals level. So, but the main brief and the main matter before the court was essentially the same that had been brought before the Court of Claims, as well as touched on by the Supreme Court in their order denying to take the case at that stage. So what happened today is that the hearing that was held 2.5 weeks ago, 3.5 weeks ago. I have no idea. I think it was the first Tuesday of August. That hearing that was done by Zoom, no amicus parties were allowed to have oral argument time on that. But in any event, the hearing that was had on that day was the Supreme Court had required the Court of Appeals to have their decision issued by today. Of course, I kind of called it that the Court of Appeals was going to wait until today to issue that decision. They beat me though, because I want to say I got the email, I think it was in the morning, and I thought they were going to issue their decision about 2:30 in the afternoon. So I was a little off about that. Let's see, what time was it? Yes, 10:39 a.m. I got the email. So they did, in fact, do it about 4 hours before I thought they would. But they, the two judges that were of the majority opinion here, they have a 21-page opinion. If you don't have anything nice to say, you're not supposed to say anything at all. So I'm not going to say much about this opinion here. I can point out to you a couple of, let's see. Basically, I'll just skip to the conclusion on this one. And this was by Judge Markey and Judge Kelly. So the conclusion states that we hold that the governor's declaration of a state of emergency, her extensions of the state of emergency, and the issuance of related executive orders clearly fell within the scope of the governor's authority under the Emergency Powers of Governor Act of 1945. We further hold that 1945 Act does not violate the Separation of Powers Clause. We therefore decline to address whether the governor was additionally authorized to take those same measures under the EMA and whether the governor violated the EMA. Those matters are moot. And then they mentioned the fact that they don't see a reason to reverse the Court of Claims order denying the motion to intervene. So essentially that group of, I think it was 5 attorneys that were trying to become officially part of the lawsuit as a party, the trial court level, the Court of Claims, they, that judge denied the motion for those attorneys to do so, and the Court of Appeals said, yeah, we really don't see a reason to change that decision. So that is that. So turning to things that make a little bit more sense and actually pay attention to what our statutes and our Constitution actually says, I'm going to turn you to the 21-page dissenting opinion by the third judge on the panel. And here's an important highlight, I guess, if you will. He says that this case involves the scope of those executive and legislative powers. The questions presented are whether the legislature in the 1945 Emergency Powers of Governor Act and the 1976 Emergency Management Act authorized a governor to rule on an emergency basis without durational limit, and whether, if the legislature did give such authority, its delegation of that power was constitutional. Essentially, those two questions are basically what the Federal District Court for the Western District of Michigan is certifying to the Michigan Supreme Court and asking the Supreme Court to hear, which oral argument will be held on that case September 2nd on those two issues. And that's the case that I was granted oral argument and the ability to address those two questions. He then says, the case comes to us under the executive orders issued by Governor Gretchen Whitmer relating to the current pandemic involving COVID-19. The executive orders, which have evolved over time, have in various iterations significantly restricted the liberties of all Michigan citizens in many ways, imposing broad economic and travel restrictions, setting forth mandatory stay-at-home orders, and promulgating many other regulations. The executive orders are backed by criminal sanctions, which provide that persons who violate them are subject to misdemeanor penalties of the EPGA, which is MCL 10.33, and the EMA under 30. It says 305.3, but that would be 405, or is it 403? At any rate, the citation is a little off there. Those orders and the associated criminal penalties were imposed solely by the executive order of the governor, bypassing the normal legislative process, which is all a problem. He then says that the questions presented here yield a clear answer on the statutory terms. The EPGA, 1945, and the EMA, the 1976 law, properly construed in para materia, do not each stand on their own, as the governor asserts and the majority holds. Rather, at least in a case such as this involving an epidemic, and for reasons discussed more fully in this opinion, the EMA's 28-day time limit controls. So he's saying the concept of in para materia, meaning when you have two subjects on the same point, even if they're in totally different parts of the law, if they're on the same point, they have to be read together. That's how it works. We don't get to cherry pick laws here. So that's essentially what he's saying there. He actually goes into a lot of detail about the different definitions, which I had originally done in my earlier writings on the topic, but as I've submitted more and more documents, I have kind of not focused on that so much. He also addresses MCL 30.417D, which is the part of the 1976 law that says it does not limit, modify, or abridge the authority of the governor to proclaim a state of emergency. So anyway, he has a slightly different angle on it than what I do. But he does address it. And he also says that the governor's interpretation of how these laws work together leads to an additional redundancy, essentially saying that the whole concept, the whole reason of having the 1976 law, the governor argues, if you look at it from her perspective, well, it basically just reiterated the 1945 law. It didn't modify it or change it in any way, shape, or form. But that's not at all what a brand new statute is even allowed to do. We can't have a new statute that simply says, hey, there's another one on the books, we're just going to follow that exactly as it is. He also points out that under the circumstances of this case, the Emergency Powers of Governor Act, the 1945 Act, is unconstitutional. And if you look at the case from the 1800s with Marbury versus Madison at the U.S. Supreme Court, it very clearly says to us, anytime you have a statute that's unconstitutional, it's void. It's void on its face. It's not enforceable. So he also points out that the Emergency Powers of Governor Act delegates legislative power to the governor, which it tries to do, and that the governor exercises full legislative power as well as executive power, the way that these two judges in this Court of Appeals panel structured their opinion to find in favor of the governor. In fact, he points out that the EPGA, as interpreted by the majority, the other two judges, commits to the governor the whole power of one of these departments, allowing it to be exercised by the same hands which possess the whole power of either of the other departments. That is precisely the evil which the separation of powers doctrine was intended to preclude and thus is unconstitutional. And he's referencing Article 3, Section 2 of our state constitution that does not allow that to happen. Let's see. So basically, in the end, this judge says that he respectfully dissents from the majority's argument on standing, whether or not the legislature can bring the claim in the first place. He dissents from their argument on statutory interpretation, meaning they're trying to totally ignore the whole in para materia argument. They're trying to say it doesn't matter if you have two statutes on the same topic. You don't have to, read them together. You can just cherry pick and do whatever you want. He's saying, no, that's not okay. And he disagrees with their constitutional interpretation analysis, which, thank goodness, because they basically threw out the entire Constitution. So that is a summary of where that sits. The rest of my prediction, I'm going to stick with. I think that Attorney Michael Williams, who represents the legislature, is fairly smart. I think he saw that coming, the same as I did. And I believe he will probably have a brief filed to appeal that to the Michigan Supreme Court. He probably will have that filed maybe Monday afternoon, Tuesday morning. And I believe the legislature, the governor's attorney will probably have their brief filed Wednesday or Thursday of this coming week. So no matter what, though, it's important to remember that the hearing that's being held, the oral argument that is scheduled to take place on September 2nd, has absolutely nothing to do with the legislature's lawsuit against the governor. The only thing that makes it tied to that case is that both cases are addressing the constitutionality and legality of the governor's executive orders. So, number one, does the governor's executive orders, do they violate the state law as it's written? The answer is undoubtedly yes. Number two, are those statutes in fact unconstitutional? The answer is undoubtedly yes. So, in general, the dissenting opinion that I was kind of reading a little bit more from here for you hammers on how the 1945 Act is unconstitutional, but doesn't really seem to put a lot of emphasis on the fact that the 1976 statute is also unconstitutional, to the extent that the government is trying to reduce or diminish our rights in any way. It's unconstitutional. To the extent that the government, no matter which branch, is trying to go above and beyond the powers that are given to it by the constitutional terms and limits, it's unconstitutional. A government, no branch of the government, ever gets more power simply because we're going through an emergency or a disaster. The Constitution was written to apply to good times and bad times, and cannot just be changed on the whim of the people that are now seeking to interpret it as they wish. It's a contract. We signed onto that contract. Our forefathers signed onto that contract exactly as it is, and it cannot be changed or amended in any way unless it is done through the proper channels. Well, the proper channels, that's how we have amendments to our U.S. Constitution, and we do have amendments to our state constitution, but those amendments aren't solidified in terms of having the designation of Amendment 1, Amendment 2. Those just literally change out part of the terms or wording of our state constitution, taking out the old part and putting in the new part. So, at any rate, there's a variety of other things I could say on that matter. What I wanted to say to you, though, is to keep in mind that what is happening on September 2nd is an oral argument on the case of those 4 doctors' offices and the 1 patient who was denied service, their case that they filed against the governor. The legislature is not officially part of that case. I haven't actually seen them file a brief. I don't think they filed a brief in that one yet. I filed a brief, and I believe it's up to 6, possibly 6 amicus briefs have been filed in that case. I believe only 4 or 5 have been accepted at this point. Mine was within the first 3, but the only attorneys that will be arguing the legality and the constitutionality of these executive orders on September 2nd, it's not going to be the attorneys for the legislature. It's not going to be the attorneys for the 5 attorneys that were trying to intervene in the legislature's lawsuit. At this point, the only attorneys that will be participating in that oral argument are the attorney representing the doctors and the 1 patient, the attorney representing the governor and the Michigan Department of Health and Human Services director, and the attorney representing the Attorney General's office, and myself. Those are the 4 attorneys who will be arguing during oral argument time on September 2nd. Again, same 2 overlapping issues with the legislature's lawsuit against the governor, but it is not the same lawsuit. Literally nothing with the legislature's lawsuit is happening on September 2nd in either the Court of Appeals or the Supreme Court. So I'm going to see real quick if we have any questions. So I believe I answered the question about what's going to be happening with the briefs and where would it go. But essentially, once both the legislature and the governor's attorneys file the briefs to appeal the Court of Appeals decision, the Supreme Court will decide whether or not they're going to accept the case. If they do, it literally becomes what's called a calendar case. It'll be docketed and essentially get dates scheduled that the different briefs and other things would be due by. And while we saw in late May and in June, the dates that the Supreme Court put out at that point, or the dates that the court rules required the briefs to be filed by, both the legislature's attorney and the governor's attorney filed their briefs so quickly in that process. That's the main reason why I was the only amicus attorney to have a brief filed in time before the Supreme Court ruled, because they went far quicker than what the normal timelines would be. So I have a feeling that both the legislature's attorney and the governor's attorney are going to move just as quickly this time around to get in front of the Supreme Court. The Supreme Court does not have to take the case. It's not an appeal by right. It's an appeal by leave. They have to ask the Supreme Court to grant them permission for their case to move forward in the Supreme Court. I do believe that's not going to be a problem, given the opinions that have come out by all of the justices on these issues throughout the summer. I don't believe that's a problem. I think the Supreme Court of Michigan will take on that appeal. I don't know how long it'll be. But in any event, while that part is pending, you still have that other case from the federal court and those two questions that were certified to the Michigan Supreme Court. That will have been heard by September 2nd. And so, in theory, the decision from that will come out far before we really see that hearing date on the legislature's lawsuit against the governor anyway. And if they've already determined that the hearings, that the executive orders are unconstitutional and they're not enforceable, I'm not sure there's really going to be much need for a whole nother hearing in the legislature's lawsuit against the governor, but we'll see. I will definitely be putting on my battle armor. That's for sure. God has put me in this place for a very specific reason. And it's obviously not to make money because I don't make money doing this. That's why I appreciate greatly all the donations that do come in to help support either the out-of-pocket costs that we have with the Restore Freedom Initiative constitutional amendment petition, where we are still gathering the remaining signatures needed to get to that 425,059 minimum goal that we have to turn in by November of this year. That will get us on the 2020 ballot. So we do have expenses with that. And yes, we do get to continue using every single signature that we have collected since the end of May, so long as those signatures are from actual registered voters and they've filled out the signature areas correctly. We also do have abilities for you to donate to the law firm, Restore Freedom with Catherine Henry, PC. That will enable me to be able to keep filing the briefs and things like this. Of course, with the most recent brief that I filed now 2.5 weeks ago, that was a $77 filing fee. And if I'm not taking on any personal cases to earn funds, then being able to come up with those court fees can get challenging. So there is that opportunity for you to donate. And my dad, who was worried about my ability to pay my personal finances without taking on basically hardly any paid cases at all since April, he made a GoFundMe so that we could have assistance with trying to make sure we can pay our bills and my student loans and all kinds of fun stuff. By the way, if you're old enough and your student loans are old enough, even though they're government loans, you don't qualify for any of those special COVID-19 student relief programs. So my student loans are full speed ahead. Yes, thank you, Andrea. That would be the link to donate. No, repealing the 1945 Act will not end her power spree. It's all a game right now. She's claiming, hey, by the way, I'm using the 1945 Act, but if you actually read her executive orders and you read the briefs that are coming out from the governor's attorneys, you could see that they don't really think the 1945 Act just totally stands by itself and that the 1976 Act just does nothing. In fact, they know the 1976 Act is the weapon in their back pocket, because the second that people really narrow in and they have their focus on the 1945 and they do something to say they do get enough signatures to get the repeal in front of the legislature, and say the legislature does in fact repeal the 1945 law, that's not going to harm us in any way. So you can go ahead and get signatures and sign it and everything else, but it's not going to erase the governor's supposed authority to go and issue these executive orders. In fact, the 1976 statute has a bunch of stuff in there that's terrible. For example, did you know that in one of the provisions, 30.421, it's MCL 30.421, it allows the governor to issue a heightened state of emergency, and that gives the governor 60 60 days of this enhanced police power over us without ever even having to consult with the legislature. Those 60 days haven't even begun because she hasn't even declared that yet. That's just one example of the horrible stuff that is in the 1976 statute being left alone. Not to mention all these additional orders and things that are coming out from the health departments and everything else under the guise of the public health code, which is a majority of which is in Chapter 333 of our laws. That has nothing to do with the state of emergency or state of disaster declaration. Nothing. So even if those, both the 1976 and the 1945 law go away, you're still going to have an issue with all these other orders that are out there. The two judges that ruled in favor of the governor are Judge Markey and Judge Kelly. How many signatures are we at? Honestly, I don't know, because at this point, I know we don't have 400,000 yet. I know we're less than that. But we need to make sure we have a solid grasp on getting out there, getting as many signatures as you possibly can every single day. Getting 425,059 good signatures is no easy feat. And obviously in the last few weeks, I've not been spending the time counting all the additional signatures. We had over 100,000 by, the first few days of July, and I haven't counted since then. We have continued to receive petitions. In fact, we have had to entirely move where the petitions are and have a whole new organizational structure and a whole new way that our validators are here validating. But counting them has not been my priority, because my priority is, number one, making sure we're out there getting signatures. Number two, that those signature sheets are in fact coming back here twice a month on the 15th and the 30th of every single month, no matter what. So we can continue to have that expectation of, yes, this is important and we are collecting those signatures. And three, my personal main focus has also been on, on getting, I guess it's twofold. Initially, the first part of this month was on writing that brief that I filed with the Supreme Court, which then allowed me to have the oral argument time on September 2nd. Also going through the orders and other briefs that are coming in since then. It's thousands of pages at this point on the legislature's case against the governor, as well as it's probably well over 1,000 pages on the other case. It's actually the one being heard on September 2nd. And so you have all of those things combined, but on top of that, I wanted to make sure that the people had a way to let others know, hey, I support the Restore Freedom work. I support the Restore Freedom Initiative, the constitutional amendment petition. I want to showcase that wherever I can. We had lots of people asking for signs of different kinds and things like that, t-shirts and whatnot. So we're not making any money off of any of it. But we do have a link on our website. If you go to the Donate and Shop tab, you can either just straight up donate if you would like to do so. Otherwise, you can shop. We essentially have two online stores. One is stuff that we've gotten solely through a local company. In fact, you can either pay to have your items shipped to you as one flat fee of $12, I believe it is, or you can go and pick them up, which is in the Grand Rapids area. Otherwise, the other items are ordered through, basically right through me. We purchased those items essentially in bulk, and we're selling those straight at cost. There's not a markup for profit or anything like that. So our main point is just to be able to get that messaging out there. So we do have yard signs available. We do have window decals to different sizes. We do have car magnets available. We have shirts, and there's a jacket. There's pop sockets. Those are not listed on that website, but they will be. What else do we have? Calendar magnets. Oh, bumper stickers. And yeah, and the window decals. Might be something else. Everything's at cost, though. So if you would like to show your support for the Restore Freedom Initiative, please do so there. The cheapest item that we have is $2. And the most expensive, I believe, is the $35, unless you need shipping. For the bigger magnet, that makes it $39. But a lot of them are less than $10. Like I said, the cheapest item is at $2, and we'd love to have your support in having those items out and about for people to be able to see and be able to learn more about our initiative and what we're doing here, as well as this other legal work that we're doing. Mike, are there any more? Oh my gosh, my contacts are freaking out. Yeah, that's kind of yeah. I don't have an easy answer for that one, but shoot, I just thought there was another one. Will I be putting up documents and the opinions from the Supreme Court justices over the summer? Mike, don't I have the 2 orders that I was referencing? Aren't those already on our website? My briefs are all on the website, and the huge portions of the different orders from the Supreme Court in the various cases I referenced in my briefs, and those, so by that way, all of those parts are actually on our website, restorefreedomkh.com. I believe the tab is resources and then documents. So they are there. And I will try to remember to get any additional court orders and whatnot also posted there. Yeah, the Public Health Code, Chapter 333, has some scary provisions. One is, regardless of state of emergency, the local health department can essentially go and get a court order to have you picked up, as long as you might reasonably have any kind of symptoms of COVID-19, again, which could be a sore throat or cough or a lot of pretty common things that people have. So as long as you have any kind of, you've given them any kind of reason to think you might have COVID-19, they can go and pick you up and then transport you to a medical facility, of course, if they're choosing, and then they can observe you, hold you and observe you, and then diagnose you and then treat you. And then, after all that, sometimes you get a hearing. In fact, the way the law is written, they have essentially up to 6 days before they even ever have to make sure that you even get in front of a judge. So you can be locked up and tested and treated and poked and prodded for up to 6 days under the Public Health Code. Has nothing to do with the 1945 law, nothing to do with the 1976 law. That law is bad news. The Public Health Code is bad news. It's got to go. Question is, if the petitions to repeal the 1945 and 1976 rules will not end her executive orders, what is our hope and what do we need to do? Number one, there's only one petition to repeal out there, and that's to repeal only the 1945 law. Why they are not trying to repeal the 1976 law, I really do not understand. If this is about freedom, they need to be repealing both of those for starters, and then to go after all these other things. But they're not. They're only going after the 1945 law, which, by the way, if you look at the legislature's website, you'll be able to look for yourself and see all of the executive orders that have been issued by any governor since 1993. Of the 605 executive orders issued between 1993 and 2019, 25 of them were based on emergency powers. Of those 25, 24 of them didn't even reference the 1945 law, didn't even say it anywhere. One of them did, but it referenced it in kind of like a historical context way. And when you get down to the later part of the order where it talks about the statutory authority, the law that gives the governor authority to make those executive orders, the 1945 law is nowhere near referenced in that. So in all of these orders, though, the 1976 law was cited as the statutory authority for these executive orders. And the interesting thing is, of all those orders, 7 of them had actually been issued or written, signed by Governor Whitmer herself. She knows the 1945 law doesn't give her the power to do this. 1976 statute is what gives her the power to do that. So what can you do since the 1945 law by itself is not controlling, and repealing the 1945 law by itself is not going to change her thinking that she has the power to do these executive orders? Well, it's not going to hurt to sign the 1945 repeal petition, so you can do that. That's like for those people when the recall petitions come out, you know, as long as you know, recalling the governor is not going to get us a brand new governor who hasn't, you know, seen everything. As long as you know that if a governor is recalled, then our state constitution, Article 5, Section 26, requires that the lieutenant governor finish that position for the remainder of the term. If you know we're going to get stuck with the Democratic Gilchrist lieutenant governor, he will then become our governor. As long as you know that and you're all about just sending the message, though, that's fine. It's kind of the same situation with the 1945 law. Signing a 1945 repeal petition, it's not bad. Even if they go the route of actually repealing the 1945 law, that's not bad. But is it going to be the thing, the catch-all, the thing that totally prohibits the governor from issuing these executive orders? No. The constitutional amendment will. The Restore Freedom Initiative constitutional amendment petition will absolutely stop that. In fact, it comes right out and says executive orders are not law, period. And when you have two laws on the same subject, you actually have to read them together. You can't cherry pick. And it says that the government, it doesn't matter if it's the Department of Health and Human Services, the Attorney General, the governor, it doesn't matter if any of them try to take away your rights. They cannot deprive you of your life, liberty, or property unless they prove that it is necessary because you are currently or imminently threatening to deprive somebody else of their life, liberty, or property. Also, no kinds of regulations that, no laws that appear to regulate the people in any way are allowed to be put into place unless it passes by a 2/3 majority in either the legislature or 2/3 majority of the voters. Simple majority, never going to cut it anymore if you want to regulate the people. It also stops any kind of administrative board from ever issuing any kind of decision or exercising any kind of authority over the people. Administrative boards, regulations, the commissions and committees and anything else, if they're not elected positions, those people have no right to make any kind of rules to regulate the people whatsoever. The government can create all kinds of boards, commissions, and committees to regulate itself. Sure, the government can regulate itself. It can't regulate the people unless it's done so in an appropriate and constitutional manner. So, there is hope. There is definitely hope. The Restore Freedom Initiative constitutional amendment petition, the one that has been circulating since May 29th, is the very petition that you want to sign and you want to circulate and you want to help us finish up how many signatures that we need to be able to turn it in November to get it on the ballot That is the best chance we have. Am I saying don't sign the 1945 petition? No, I'm not saying that. That's your choice. But to answer the questions that have been asked of me, the hope comes from this constitutional amendment petition. Hands down, absolutely. Will the oral arguments be live and the public will be able to view? Yes, I will be participating by Zoom because that is what the court has decided to do. But as always, the Supreme Court actually has their own YouTube channel, and I believe right on the front page of the Michigan Supreme Court's website, they actually have a embedded link to their YouTube channel where you can see the video that will be played that day. What did I say to make Maya say that she's going to go shopping?
Donate.
Oh, yeah. That's awesome. Thank you, Maya. Yes, Rachel, the Restore Freedom yard signs are very high quality, absolutely, and done by a local company to boot. Awesome. I see a lot of questions about the public health code. I can't see much anymore. My contacts are pretty dead. The Restore Freedom Initiative constitutional amendment petition absolutely addresses the problems created by the public health code. If you're looking for something that's possibly quicker than that, repealing the parts of the public health code, or in fact repealing the entire public health code, is something that can be done by initiative, just like the 1945 repeal is being done. Absolutely. It's chapter 333 is where the public health code provisions are that I'm talking about. I don't have the specific MCL beyond that. I've referenced two of them repeatedly in prior videos. I just don't have them right now. In fact, if you go and look at the videos I've done on specifically, the title is something about the 3 petitions out there, I do specifically state those MCL numbers several times throughout those videos. Where is the constitutional amendment? No, the Restore Freedom Initiative petition will not be on the 2020 ballot. We were trying to get it on the November 2020 ballot, and that would have been, had we been able to have enough signatures by July 6th, turned into the Secretary of State. We did not have enough signatures by that point, so we are able to continue collecting signatures and utilize all those signatures collected so far, but that will put us on the November 2022 ballot. If the repeal 1945 statute, if that petition gets enough signatures, it goes to the legislature to act within 40 days. If the legislature does not vote to go ahead and repeal the 1945 law, if they don't have enough signatures, or they just choose not to do anything with it, that they can, Unlock Michigan, Stand Up Michigan, can then choose to put it on the next general election ballot, which means it'll be on the exact same ballot that the Restore Freedom Initiative constitutional amendment petition will be on. It's not going to be done any sooner. The constitutional amendment, if you're looking for where to sign it, or how to become involved, or how to be trained as a circulator, or ideas on where to have signing events, that kind of thing, you can certainly go to our website, which is restorefreedomkh.com. That's restorefreedom, K as in Catherine, H as in Henry.com. And all that information is on there. No, we're not circulating the Restore Freedom Initiative petition again. It's literally the same collection period, if you will. Every signature that we collected from the end of May all the way through today's date, they are all going to be collected and turned in at the same time in November. So if you've already signed it, do not sign the Restore Freedom Initiative petition again, because you can only sign once. But do make sure that you are out there helping to convince your friends, neighbors, family members, coworkers, and people you go to church with to sign it. And host signing parties or have garage sales where you have it advertised as a signing event. In fact, any kind of signing event, even if it's just attached to your garage sale, you can go ahead and submit that through our website. And our events team will go ahead and make sure that it is listed on our website and on our Facebook page with a full Facebook event for it and everything. So please make sure to take advantage of the ways that we are advertising it as well. We have been collecting this one the longest. The Restore Freedom Initiative petition has been out since the end of May, whereas the Unlock or Stand Up Michigan petition to repeal the 1945 law, they came out collecting signatures, I want to say around July 8th. And of course, the recall petitions are not out yet. So those are the two main petitions out there. If you signed before July 4th, you did not sign the Unlock Michigan petition. You did sign the Restore Freedom Initiative petition. So it looks like I've actually finished answering all of the questions for tonight. Thank you so much for tuning in. Do keep in mind, we do have that store I mentioned, so you can show your support that way. Again, those funds are not, there's no profit anywhere in there, and you don't get free juice or anything else like that with those. If you order a yard sign, you simply get a yard sign at the cost. You also have the ability to get car magnets, t-shirts, decals for your, window decals for your home or business or your cars. There's also calendar magnets. Everything is on there. Has all the fees and everything included. The cheapest item we have on there is $2. So we do hope that you go ahead and take advantage of that and place some orders. That's done right through our website, restorefreedomkh.com. And you can click on shop or donate. So that's Restore Freedom, K as in Catherine, H as in Henry.com. Thank you so much, everyone, for tuning in. I will definitely let you know if there are other updates coming with any of these lawsuits happening. But do stay engaged, stay informed. Don't take any of these situations lightly. Make sure you are constantly out there talking to your friends, neighbors, loved ones, making sure people know, number one, that they need to read the Constitution. They need to read the U.S. and Michigan Constitutions. And number two, that they are being active, that you are encouraging people to sign the petitions, to help circulate the petitions, to get the word out to everyone that we need to have 425,000 signatures turned in. And it's going to take a team of people who truly believe in their freedom. So thank you so much. Have a wonderful night, and I'm sure I'll see you guys at some point this weekend. And don't forget to go to Florentine's Pizzeria and Sports Grill. Is that right? I think I'm saying that right. On the corner of Ivan Rest and 28th Street in the Grand Rapids area. I believe that might be Granville or Wyoming. Wonderful food. Chicken piccata is amazing, but their pizza's good. Their salads are good. Everything is good. So please make sure to stop out and see them. They also love supporting your freedom as well. So thank you so much, everyone. Have a wonderful night.